Lasting powers of attorney are legal documents that allow you to nominate people as your attorneys to make decisions for you, typically in the event you lose mental capacity. There are two different types of lasting power of attorney. There is a lasting power of attorney for financial decisions, and there is a lasting power of attorney for health and care decisions. The lasting power of attorney for financial decisions allows your attorneys to access your bank accounts. It allows them to pay bills on your behalf, write checks on your behalf. It also allows them to speak to pension providers, speak to utility companies. They would be able to make investments and sell property. Lasting powers of attorney for health and care decisions allow your attorneys to make decisions such as where you live, the type of care you receive, who visits you, who you speak to, so very much your day-to-day welfare. There is also an option to give your attorneys authority to consent or refuse life-sustaining treatment. With the financial decisions lasting power of attorney, there is also an option to put a lasting power of attorney in place specifically for your business. You might decide, for example, that you want one person to look after your finances generally, but perhaps you want your business partner to be able to make decisions specifically in relation to the business. If you don't have a lasting power of attorney in place and you lose capacity, unfortunately it's too late to put a lasting power of attorney in place. Whoever wants to step in and help manage your affairs and make decisions for you would have to make an application to the Court of Protection. That is a very expensive process, it's very time consuming, and it's actually quite intrusive. You have to give a lot of information about the individual who lacks capacity and also a lot of information about the individual who's applying for the deputyship order. With the Court of Protection, it is very unlikely that you would successfully obtain an order to look after someone's day-to-day welfare generally. Typically, the Court of Protection will only issue orders if there's an immediate risk of harm or there is a life or death situation. That can be particularly problematic if, for example, you have a family member who wants to be able to care for you at home, but the local authority feel it's more appropriate for you to move to full-time residential care. Ultimately, the local authority would be able to ignore the views of the family. My advice with lasting powers of attorney is if you know who your attorneys would be, there's really no reason to delay putting them in place. There is the possibility that you will receive a diagnosis that means your faculties might deteriorate gradually over time, in which case you then have the opportunity to put a lasting power of attorney in place. I would make the following points, that if you did receive such a diagnosis, you're probably not going to want the additional hassle of having to come and see a solicitor, but also there is a very real risk that you won't have that opportunity. You could, for example, have a stroke, you could have an accident, which means, unfortunately, your capacity is lost immediately.